Welcome to a Point in Limine webinar. Point in Limine provides your essential dose of legal knowledge. Point in Limine aims to make general legal knowledge and information easily accessible to the average South African citizen. Please note that all the information shared during this webinar and generally by Point in Limine and through all Point in Limine platforms is shared as legal knowledge only and is not to be construed as legal advice. Thank you for attending this presentation. Please follow us on YouTube, Instagram, LinkedIn, and Facebook. Today's topic is on marriage in South Africa from a legal perspective and will be presented by Mbonisi Ndlovu.
Why ask all the relevant questions about marriages after you've entered into one? My name is Mbonisi Ndlovu, and today I will be unpacking the various marriage systems that are applicable in South Africa and try and simplify the legal jargon around marriage laws. Before we perhaps get into it, let us firstly understand what a valid marriage looks like in South Africa. There are 4 requirements to actually enter into a marriage in South Africa. The first one is that both spouses have to be 18 years or older. If you happen to be 16 years, however, you can get married with your parents' consent. The second requirement is that the marriage itself has to be lawful. By lawful, I mean you cannot decide to actually get married to your sibling because of the close relationship, the blood relationship that you both share. And secondly, you cannot actually get married to 10 spouses. It is illegal unless you are married customarily. The third thing is that the marriage itself has to be entered into before a marriage officer and 2 witnesses. And the marriage officer will have you both sign a certificate which is then sent to the Department of Home Affairs to be registered. Now that we understand what a valid marriage looks like, we will now look at the different matrimonial or perhaps marital property systems applicable in South Africa. If you've heard of the terms in community of property, out of community of property, and out of community of property without accrual, then you know what marital property systems is. Perhaps let me just explain the term community of property. The term community of property simplistically means that coming together of 2 spouses' estate and forming one estate. What is an estate, if you may ask? An estate constitutes of assets, properties, cash, as well as debts, liabilities, and anything that depreciates your net worth, so to speak. So when both of these come together, they make a single estate. And when both parties' estate come together into a joint estate, that is what constitutes a community of property. Let us look at the very first marriage, which is a default marriage in South Africa, which is a marriage in community of property. A marriage in community of property is concluded when there is no antenuptial contract between the spouses. It is automatically in community of property. What is an antenuptial contract, you may ask? An antenuptial contract is a contract between 2 spouses where they conclude the terms as well as the ways in which their marriage is going to be regulated when it comes to ownership and the likes. The second requirement, the second characteristic of a marriage in community of property is that what is mine is yours and what is yours is mine. So essentially, we both equally share each other's estates or assets in equal and indivisible shares. And finally, the other characteristic is that you will require your spouse's consent for entering into contractual acts as well as entering into legal proceedings, that is to sue other people, etc., etc. Now, this schematic representation actually represents how a marriage in community of property would look like. A and B come together and find and contemplate getting married. A has a 20,000 Rand worth of their estate, and B has 40,000 Rand worth of their estate. They then decide to get married, and they actually conclude a valid legal marriage, which is in community of property. both their estates come together and become one. As you would see, the block is now bigger and the block is now gray. So they effectively share everything they own together during the marriage. Now let's assume that both A and B's estates during the marriage does not increase or decrease upon dissolution of the marriage, or perhaps termination of the marriage. That is to say that at the end of the marriage, right, their estate will be split into half. When does a marriage end? Only in two instances. Number one, through death. Number two, through divorce. Those are the two instances a marriage is terminated. So upon those two instances, A and B will get to share equally the joint estate, and each of them will have an equal share of the joint estate. Now, what are the advantages and disadvantages of marriages in community of property? The advantage is that both spouses get to share in each other's wealth during and before marriage. And now, what are the disadvantages? The disadvantages would be that you get to share in each other's debts and liabilities. Secondly, if one of the spouses during the marriage becomes insolvent, by that I mean blacklisted, the other spouse will also bear the risk of all the creditors attaching their assets. And number three, as I've explained, is that there is a restriction in contracting. So you will always, more than always, actually require your spouse's consent. The second type of marriage, marital system that is recognized in South Africa, is a marriage out of community of property without accrual. This happens where spouses enter into an antenuptial contract before getting married. Essentially, what this marital system is characterized by is that you retain what is yours before and during marriage and after marriage. You both get to share only in the growth of the estates, that is, the profits and the losses at the end of the marriage. The accrual system automatically applies unless expressly excluded. You may ask again, what is the accrual system? An accrual simply means accumulation or perhaps growth, right, of the estates. So we look at the actual growth after the marriage, that is at death or divorce. We then subtract the value with the initial value of the estate. We will just see that in the next schematic representation in the next slide. The creditor spouse can have a claim for an equal amount equal to half the difference between the growth of the spouses, which we will see just now, right? And in the antenuptial contract, you can always exclude inheritances, legacies, donations from the accrual. Legacies and inheritances basically are things that are given to you in a will. So those can be excluded from the actual accrual or the growth or the accumulation of your estates. Now, this here is an actual representation of a marriage out of community of property with accrual. Again, A and B decide to get married. They actually contemplate getting married. A's estate is 20,000 Rand and so is B's. They then get married. However, their estate do not join as was in the community of property marriage. B's estate doesn't grow. And then A's estate actually grows by 60,000 Rand, making it to be 80,000 Rand during marriage. And finally, here is how the accumulation of the growth is now split at the termination of the marriage. A's estate has grown by 60,000 Rand. That 60,000 Rand will then come into the accumulation bag, which is then split into half. Then A will get the 30,000 Rand of the 60,000 Rand, which will form into his estate. And then B will also share into into that accumulation box that A has acquired at the termination of the marriage. Again, only in 2 instances does a marriage terminate, death or divorce. And therefore, A's estate is much bigger and than it was before, and B's estate is also equal to his because they're now sharing the equal growth of the other party's estate. And so what are the advantages and disadvantages of a marriage out of community property with accrual? Number 1, there is a protection of insolvency. If the husband gets insolvent or blacklisted, then the spouse or the wife will not be affected by that insolvency or blacklisting. They then get to share equally on the profits and losses made during the marriage. And finally, there's no restriction in contracting. That is, you do not require your spouse's consent for every contractual act. The third disadvantage is that spouses need to keep a record. And thirdly, and finally, which is the marriages out of community property without accrual. Now, this obviously speaks to the growth. There isn't the consideration of the growth in that marriage. The accrual system is excluded explicitly in the antenuptial contract. And now each spouses get to keep their estate separately. Now, this is how a schematic representation of a marriage out of community accrual without accrual looks like. Firstly, A and B decide to get married. They contemplate getting married, and then they actually get married. During their marriage, their estates grow and decrease respectively. However, at the end of the marriage, there's no sharing. So as you can see, it is a clear divide. There's no sharing of growth. There's no sharing of anything in this type of a marriage. Ultimately, both spouses retain their own estates without having to share, and the only thing that combines them or perhaps joins them or unionize them is the actual institution of marriage. However, they operate as though they are unmarried. So this would typically the disadvantages of this would be both spouses have separate ownership. There's no liability for each other's debts. There's no sharing of profits and losses. And finally, there's no restriction in contracting capacity. This is exactly the same as the previous marriage. However, in this instance, you are clearly divided. It's as though you're strangers living together because you can constantly contract. Disadvantages is that there's no automatic of sharing of their growth, and also the weaker spouse's estate cannot quite claim from the other spouse's estate, which is unfortunate because there's a clear divide. So now, who might consider, or perhaps which spouses may consider to actually get married in this type of a marriage? This would be in instances where both spouses have accumulated their wealth over the years and they decide, perhaps it's time that we get married. And in this type of a marriage, both spouses will then retain whatever that is theirs and there won't be any sharing. Perhaps the other spouse is business risk inclined and the other spouse is business risk averse. And that will obviously cause a huge impact on each other's estates. And now we're going to look at customary marriages. Customary marriages are the most prominent and also controversial in South Africa because of the fact that South Africa has got a lot of diverse cultures. And remember, customary law is not static, it's ever evolving and therefore open to interpretation. Now, what are the requirements for a valid customary marriage? Number 1, there has to be 2 spouses who, or perhaps even more at times, who are 18 years or older. 16 years requires a parental consent to the marriage. Secondly, consent to the marriage by the spouses. So both the spouses have to consent to enter into a customary marriage. thirdly, which is the most controversial one and open to interpretation, is that the marriage itself has to be negotiated, entered into, or celebrated in accordance with the customs of that culture. Now, let us have a look at various case laws just for clarity, to clarify what constitutes a valid customary marriage. In 1998, Mabena versus Letswalo in the Supreme Court of Appeal contended that lobola alone is not sufficient. There has to be the handing over of the bride for there to be a valid customary marriage. This was further confirmed in Mgabe versus Minister of Home Affairs in 2016 in the High Court, where the court said lobola alone is not a determining factor to conclude a valid marriage customarily. Furthermore, in 2019, most recently, Mbungela versus Mkabi in the Supreme Court of Appeal also confirmed this, to say lobola is not sufficient to actually conclude a valid customary marriage. Most recently, in 2020, in Tsambo versus Sengadi case, as you may perhaps know, the late Double HP, who is a prominent rap artist in South Africa, who died when there was a bit of contention happening regarding his marital status. So in this instance, there was lobola that was actually, there were lobola negotiations. And right after that, Double HP actually paid for the lobola part of it and not completely. Now, the family contended that because there was only part payment of the lobola negotiations, there wasn't quite a valid marriage, because there was supposed to be an extra step of actually handing over of the bride and other customs which the culture requires. Now, right after the deceased had passed on, by the deceased I mean Double HP, the family did not want to recognize Ms. Sengadi, who happened to contend that she is the actual wife of the late Double HP. The Supreme Court of Appeal basically confirmed that, look, there must be a specific consideration of various cultures. So different cultures practice differently. So each case must be determined in accordance with their own merits. So for instance, as I said earlier on, there's various cultures in South Africa, and therefore different cultures practice differently. Therefore, we should consider the specific case of each matter with its specific merits. That was the conclusion in that matter. Now, say for instance, you are married customarily and you want to actually change your marital system to a civil marriage. Can you do that? Absolutely. If you are currently married in a monogamous customary marriage, by monogamous I mean there's only two parties involved and not more than two spouses involved, you may convert your marriage into a civil marriage. That is very much possible. The only thing that you need to do is to follow the requirements of the civil marriage that were mentioned earlier on. That is, you have to be both 18 years or older. The marriage must be lawful. The marriage has to be entered in before a marriage officer and two witnesses. And finally, the marriage officer must basically have your marriage registered at the Department of Home Affairs within 3 months. If no antenatal contract was entered into before the customary marriage was concluded, you cannot actually convert your customary marriage, which is currently in community of property, to a customary marriage which is out of commercial property. It is therefore important that if you want to enter into a out of community marriage, you must actually enter into an antenatal contract prior to entering into a customary marriage, which may later be converted into a civil marriage. Now, the last type of union, or perhaps marital system, not even a marital system, a type of union that is recognized in South Africa is civil union. This was first recognized in 2006. This is now for same-sex couples. It is also open for opposite-sex couples. This is for instances where parties who do not want to get married in the strict sense, as we may know that marriage itself is an institution that is closely linked to religion and belief. Therefore, parties who feel strongly that they don't perhaps want to get married in the strict sense, they can absolutely enter into a civil union. The rights, responsibilities, legal effects are exactly the same as that of a civil marriage. And of course, the age of the parties has to be 18 years and older. It can never be any other party younger than that. Even if you are 16 years, unfortunately, you can't actually get into a civil union in comparison to a party entering into a customary marriage and a civil marriage. Say, for instance, you are currently married in community of property and you would like to change your marital system to that of out of community of property. Is that even possible? Absolutely, you can. The only thing that you need to do is actually apply to court. It's a high court application, can be expensive, and takes a lot of months to actually convert this. The only thing that you need to do is actually convince the court that, number one, there are sound reasons for the proposed change. Right? You can't just wake up one morning and say to your spouse, honey, I think it's time that we change our marital status without a specific and solid reason. A solid reason may be, for instance, you are now perhaps venturing into business risk business, and now you don't want to actually affect your spouse's estate. Then you can actually inform the court, and then if the court is satisfied, then may approve of your change. The second reason is that there must be sufficient notice to all the creditors of the spouses. That is your spouse as well as yours. For instance, if your spouse has an account, a clothing account, or perhaps has a furniture account, or a car account, or a bond, all those creditors, including your creditors, have to be notified timelessly and be given a notice via registered post, so that they're actually aware of the intended change of your marital system. And thirdly, you must confirm to all the parties that there will not be any prejudice by the proposed change. So there will not be prejudice by the change. By that I mean, if one of you changes the marital system from that of in community of property to that of out of community of property, nobody will be prejudiced by this act. Thank you so much for joining us for this incredibly insightful session. We hope that you enjoyed and that you will obviously spread the word and inform others, because as the saying goes, just as light drives out darkness, knowledge drives out ignorance. So let us keep on getting ourselves informed so we can make informed decisions. From myself, Mbonisi Ndlovu, and Point in Limine, have a great day and see you again next time.
We hope you enjoyed the presentation. Please like this video and subscribe to our channel. Press the notification button to be notified as soon as we post new content and videos. See you next time for your essential dose of legal knowledge.